Hello, my dear judicial aspirants. This is part 2 of Law of Torts MCQ series. आप पार्ट 1 डिस्क्रिप्शन बॉक्स में दिए गए लिंक से देख सकते हैं. So let's start. Question number 51. Which statement is correct of an act of tort? Option A, it is a civil wrong. Option B, all civil wrongs are not tort. Option C, it gives in rem. And option D, all of the above. And the correct answer is option D, all of the above. Question number 52. A tort is a breach of duty, which is option A, imposed by the parties, option B, imposed by the law, option C, imposed by the penal law, and option D, imposed by the society. And the correct answer is option B, imposed by the law. A tort is a breach of duty which is imposed by the law. Question number 53. Who said that a liability in law of tort arises only when the wrong is covered by anyone or the other nominate tort? Option A, Fraser. Option B, Winfield. Option C, Blackstone. And option D, Salmond. And the correct answer is option D, Salmond. Next, question number 54. In a suit for damages on the ground of malicious prosecution, what is required to be proved by the plaintiff? Option A, that he was prosecuted by the defendant. Option B, that the prosecution was instituted without a reasonable and probable cause. Option C, proceeding for malicious prosecution terminated in favor of the plaintiff. And option D, all of the above. And the correct answer is option D, all of the above. Question number 55. Which of the following famous case is related to an exception to the application of the doctrine of voluntary non-fit injuria based on rescue cases? Option A, Hines versus Harwood. Option B, Padmavati versus Dugganaik. Option C, Asbe versus White. And option D, Winterbottom versus Wright. And the correct answer is option A, Hines versus Harwood. Next question, question number 56. In which case Lord Dunedin said a man must be vigilant to the guard against possible incidents, not against imaginary incidents? Option A, Stanley versus Powell. Option B, Farden versus Harcourt. Option C, Holmes versus Mathur. And option D, Sridhar Tiwari versus UP State Road Transport Corporation. And the correct answer is option B, Farden versus Harcourt. Next question, question number 57. If one person spits on the face of another person, then that person is guilty of option A, assault, option B, battery, and option C, criminal force, and option D, both A and B. And the correct answer is option B. If one person spits on the face of another person, then that person is guilty of battery. It's a very important question. Next question, question number 58. Next question, question number 58. The distinction between sins, knowledge of risk, and violence, consent to undertake risk, has been pointed very clearly in which case? Option A, Bowater versus Rowley Regis Corporation. Option B, Imperial Chemicals Industries versus Staples. And option C, Dan versus Hamilton. And option D, Hines versus Harwood. And the correct answer is option C, Dan versus Hamilton. Question number 59. What do you understand by damnum? Option A, loss of health. Option B, loss of money only. Option C, loss of property only. Option D, loss of money, health, and comfort, etc. And the correct answer is option D, loss of money, health, and comfort, etc. Next question, question number 60. Stanley versus Powell and Holmes versus Mathur are the case related to? Option A, act of God. Option B, necessity. Option C, inevitable accident. Option D, nuisance. And the correct answer is option D, nuisance. Stanley versus Powell and Holmes versus Mathur are the cases related to nuisance. Next question, question number 61. A principal is least likely to be found liable for the torts of an agent if the agent is Option A newly hired employee. Option B, a youth. Option C, an independent contractor. Option D, found responsible for having committed an international tort. And the correct answer is option C, an independent contractor. Then a principal is least likely to be found liable for the tort of an agent if the agent is an independent contractor. Next question, question number 62. In which one of the following cases did the Supreme Court of India give a ruling that sovereign immunity of the state is subject to the fundamental rights? It's a very important question. And the options are: option A, State of Rajasthan versus Vidyavati; option B, Swam Sundar versus State of Rajasthan; option C, Kasturi Lal Ralia Ramran Jain versus State of UP; and the option D is People Union for Democratic Rights versus State of Bihar. And the correct answer is option D, People Union for a Democratic Right versus State of Bihar. It's a very important case. Next, uh, next question is question number 63. In torts, option A, injurious and damnum is actionable only in case there are actual damages. Option B, damnum sign injuria is actionable only in case there is a actual damage. Um, Option C, injurious and damnum is actionable even if there are no damages. And option D, damnum sign injuria is actionable even if there are no damages. And the correct answer is option C, injurious and damnum is actionable even if there are no damages. Next question, question number 64. It's a problem based question. Uh, X was suspected of stealing a bottle of liquor from the bar of Y's company where he was employed. He was asked by two of the security guards to go to Y's office. X assented and he was invited in the waiting room, and the two guards remained somewhere in the neighborhood. There is option A, no case of false imprisonment because X was not aware of it. Option B, no case of false imprisonment as X was merely detained on ground of reasonable suspicion. Option C, false imprisonment from the moment X assented to the guards. Option D, false imprisonment from the moment X extended the waiting room. And the correct answer is option C, false imprisonment from the moment X assented to the guard. Next question, question number 65. Between A and B and a third person, C, the tort of conspiracy is committed when option A willfully causes damage to B, A and B try to cause damages to C but no damage is done to C. Option C, A and B willfully causes damages to C and actual damages result therefrom. And option D, A and B plan to cause damage to C. And the correct answer is option C, A and B willfully cause damage to C and actual damage results therefrom. Next question, question number 66. The doctrine of res ipsa liquidator was applied by the Supreme Court in which case? Case number option A, Jasbir Kaur versus State of Punjab. Option B, Alka versus Union of India. Option C, Asaram versus MCD. And option D, MCD versus Subhagwanti. And the correct answer is option D, MCD versus Subhagwanti. Next question, question number 67. In tort of conspiracy, the purpose of combination must be to option A, obtain benefit for the combiners. Option B, violates legal rights of the victim. Option C, protect the interest of the combiners. Option D, cause damage to the victim. And the correct answer is option D, cause damage to the victim. Next question, question number 68. Where a person commits a public nuisance. Option A, he is liable to criminal prosecution under the IPC 1860. Option B, he may be proceed against under section 91 of the CPC. Option C, he is liable to damages in a suit at the instances of a private individual who suffers special damage by the reason of nuisance. and last option is all, all of these. And the correct answer is option D, all of these. Next question, question number 69. Uh, in a case of false imprisonment, option A, intention of the defendant is necessary to constitute the tort. Option B, that wrong could not be constituted without the knowledge of the person wronged. Option C, the wrong person be constituted even by the curtailment of partial liberty. Option D, the wrong could be constituted even without the knowledge of the person wronged. And the correct answer is option D, the wrong could be constituted even without the knowledge of the person wronged. And next question, question number 70. Which one of the following can be successfully pleaded as a defense in an action for conspiracy? And the options are option A, the combination is for creating an equal bargaining capacity. Option B, the combination is for eliminating monopoly. Option C, the combination is for protecting one's armed trade. Option D, the combination is in accordance with their business policy. And the correct answer is option B, the combination is for eliminating monopoly. Next question, question number 71. The term sinister is related to which one of the following signboards? It is a very important and tricky question. And the options are option A, trespassers will be prosecuted. Option B, beware of dogs. Option C, no parking. Option D, no admission without permission. And the correct answer is option B, beware of dogs. It's a term sinister. Next question, question number 72. Peak versus Garni is a famous case related to option A, mistake. Option B, misrepresentation. Option C, fraud. And option D, frustration of contract. And the correct answer is option C, fraud. Pick versus Garnier case is related to fraud. Next question, question number 73. The doctrine of civil conspiracy was enunciated by the House of Lords in option A, Walspe versus Anley case. Option B, Mughal Steamship Company versus MC Gerger Gow and Company. Option C, Allen versus Flood. Option D, Queen versus Leithern. And the correct answer is the doctrine of civil conspiracy was enunciated by the House of Lords in Queen versus Leithern. Next question, question number 74. A music teacher committed sexual intercourse with a minor girl, having obtained her consent on the pretext that the same is required to improve her voice, was held guilty of rape in which case? And the options are option A, R.N. Catherine. Option B, Ashby versus White. Option C, Dongue versus Stevenson. And the option D is R versus Williams. And the correct answer is option D, R versus Williams. And next question, question number 75. For the tort of false imprisonment, there should be option A, total restraint on the liberty of a person. Option B, partial restraint on the liberty of a person. Option C, means of escape. And option D, all of the above. And the correct answer is option D, all of the above. फटाफट हम कर रहे हैं क्योंकि हम आपका समय ज़्यादा नहीं लेना चाहते हैं क्योंकि समय कम बचा है और रिवीजन ज़्यादा करना है. Next question, question number 76. Tort of defamation is divided into libel and slander in option A, English law only. Option B, Indian law only. Option C, both Indian law and English law. Option D, none of the above. And the correct answer is option A, English law only. Tort of defamation is divided into libel and slander in English law only. Next question, question number 77. Nuisance as a tort was defined as unlawful interference with a person's use or enjoyment of land or some right over or in connection with it by it held by option A, Winfield. Option B, Salmond. Option C, Pollock. And option D, Underhill. And the correct answer is option A, it was held by Winfield. Next question, question number 78. Tort of defamation can be in respect of a option A, living person only. Option B, deceased person. Option C, both A and B. and option D either A or B. And the correct answer is tort of defamation can be in respect of both living person and deceased person. Next question, question number 79. Case of Kasturilal versus State of UP is related to option A fraud of a state, option B contractual liability of a state, option C vicarious liability of a state, and option D none of the above. And the correct answer is uh, Kasturilal case is related to vicarious liability of a state. Next question, question number 80. Which of the following statement is incorrect? Option A. Malicious prosecution consists of instituting unsuccessful criminal bankruptcy or liquidation proceedings. Malicious prosecution consists of instituting unsuccessful legal proceedings, civil or criminal. Option C. Action for malicious prosecution will not succeed if no damage result thereby. Option D. The criminal prosecution should be without any reasonable or probable cause. And the correct answer is option B. Malicious prosecution consists of in instituting unsuccessful legal proceedings, civil or criminal. It's incorrect. Rest all are correct. Next question, question number 81. Distress damage fission means option A person in possession of land could seize the trespassing cattle or other chattels. Option B, he can detain them until compensation has been paid to him for the damages done. Option C, both A and B, and option D, only A is correct. And the correct answer is option C, both A and B. Next question, question number 82. Which of the following statement is true? Option A, false imprisonment consists of a total restraint on the liberty of a person. Option B, however short the restraint may be on the liberty of a person, it amounts to false imprisonment. Option C, imprisonment to be false must be without lawful justification. And the option D is all of the above. And the correct answer is option D, all of the above is statement as true. Next question, question number 83. Nuisance recognize option A the concept of no fault liability, option B liability based only on fault, option C liability based only on imputability, option D none of the above. And the correct answer is option A the concept of no fault liability. Nuisance recognizes the concept of no fault liability. Next question, question number 84. Negligence is culpable carelessness. The viewpoint was expressed by option A Pollock, option B Halsbury, option C Salmond, option D Winfield. And the correct answer is negligence is culpable carelessness is in the viewpoint was expressed by Salmond. Next question, question number 85. Tort is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of contract or the breach of a trust or the other merely equitable obligations. This definition of tort is given by option A Winfield, option B Salmon, option C Pollock, and option D Clark and Lindsay. And the correct answer is option B Salmon. Next question, question number 86. The general remedy in law of tort is option A action for damages, option B action for injunction, option C specific restitution of property, option D action for unliquidated damages. And the correct answer is option D action for unliquidated damages. Next question, question number 87. Liability in tort depends upon option A quantum of damages suffered, option B involvement of intention, option C infringement of legal rights, and option D effect on public interest. And the correct answer is option C infringement of legal rights. Liability in tort depends upon infringement of legal right. Next question, question number 88. An act done as act of state. Option A can be questioned in municipal court with all facets. Option B can be questioned in municipal courts to a limited extent. Option C cannot be questioned at all in municipal courts. Option D none of the above. And the correct answer is an act done as act of a state can be questioned in municipal court to a limited extent. Next question, question number 89. The term novus actus interveniens means option A directness of damages, option B remoteness of damages, option C direct and remote damages, option D foreseeable damages. And the correct answer is option B. The term novus actus interveniens means option B remoteness of damages. Next question, question number 91. Who propounded of pigeonhole theory? It's a repeated type question and ये बहुत बार पूछा गया है. So and options are option A Salmon, option B Benfield, option C Clark and Lindsay, and option D Austin. And the correct answer is option A Salmon. Next question, question number 92. It is plaintiff's has a right, he must have means to vindicate and maintain it, and a remedy if he is injured in the exercise or enjoyment of it. Ashley versus White. The above rule was laid down by option A Salmon, option B Hold Chief Justice, option C Blackburn Justice, option D Winfield. And the correct answer is it was laid down by option B Hold Chief Justice. Next question, question number 93. Remoteness of damage is determined by option A the test of directness, option B the test of reasonable foresight, and option C both A and B, and option D none of the above. And the correct answer is remoteness of damage is determined by option C both A and B, the test of directness, and option B the test of reasonable foresight. Next question, question number 94. Last opportunity rule is option A an exception to contributory negligence, option B a modification to contributory negligence, option C and alternative to contributory negligence, option D supplements to contributory negligence. And the correct answer is last opportunity rule is supplements to contributory negligence, option D. Next question, question number 95. The maxim solus populis suprema lex means option A no man is above the law, option B the welfare of the people is the supreme law, option C the defense of statutory authority is the supreme law, and option D none of the above. And the correct answer is the maxim solus populi supreme lex means the welfare of the people is the supreme law. Next question, question number 96. A man's reputation is his property and if possible more valuable than other property. It was so observing. It's a very important question. And the options are option A Manson versus Tucson Limited, option B Dixon versus Holden, option C Yusufov versus MCM Pictures Limited, option D Ostick versus Dowling. And the correct answer is option B Dixon versus Holden. Next question, question number 97. Which of the following is not actionable claim? A right to claim areas of rent of house, option B right to claim areas of maintenance, option C right to claim decretal sum, and option D right to claim money payable under life insurance policy. And the correct answer is right to claim decretal sum is not actionable claim, rest all are actionable claim. Next question, question number 98. If a person wants to bring an action under law of torts for the tort of public nuisance, he must have to prove that option A the injury was direct and substantial only to him, option B the injury was criminal in nature, option C the injury affects the public at large, option D none of the above. And the correct answer is if a person wants to bring an action under law of torts for the tort of public nuisance, he must have to prove that the injury was direct and substantial only to him, option A. Next question, question number 99. Which among the following is the correct response? Option A when two or more person commits a wrong against the same person, they may be independent tortfeasors or joint tortfeasors. Option B when two or more person in concert commit a wrong against the same person. They are called joint tortfeasors and are jointly liable. Option C, both the above statements are substantially correct, and option D, both the above statements are correct. And the correct answer is both the above statements are substantially correct. And the last question of part 2, question number 100, whether for a wrong both tortious and criminal liability may arise. And options are option A, only tortious liability may arise, and option B, only criminal liability may arise, and option C, both the liability may arise, and option D, none of the above. And the correct answer is option C, both the liability may arise. So in this second part, we have discussed 50 most important MCQs of law of torts, which generally ask in judicial service examinations. Thanks for watching part 2 of law of torts MCQ series. Please like, share and subscribe my channel for part 3.